Welcome to the third session of the Law-Fi DAO Policy Working Group of the Community Building Subcommittee. Lawyers, we love long titles and acronyms for things, so get amongst it. The discussion last week was like mental gymnastics for me, and I'm sure for a lot of others. It basically made us feel like, or at least me, that we've been treating these tokens as property rights as a shorthand without actually asking the right questions of what is it that we have or that we have a right to use when we're interacting with blockchain protocols. So I think that we'll continue that discussion a little bit today. Welcome, James.
Hi, Joni.
and try to get to some sort of position, at least between ourselves, on what we think the strength is for existing property rights versus this licensing approach, and what would be the adjustments needed to that second criterion with the proposed 3 criteria for a data object to exist in this third class of property. So to jump straight into it, and I really want to welcome you, James. I might throw to you to give a bit of a background of yourself.
Sure.
And you've made some email comments to me, which would be fantastic if you could relay to the group. And as an opening, I'll facilitate some calls. So please put your hand up and I can direct the conversation to you so that you can add your insights, and maybe we get to an outcome by the end of this call and be able to deal with chapters 6 to 11. But James, do you want to give a bit of a background and then an opening on your perspective on this proposal?
Yeah, sure. Thanks, Joni. So I've known Joni for a couple of years now. So I'm a partner in the intellectual property team at Mills Oakley. And we've been sort of working on a whole bunch of different crypto-related and digital asset-related matters over the last couple of years. And so I thought I'd get involved. I have that litigation and dispute sort of background, and that's what I do. I've been doing that for about 20 years. But this is a particularly interesting topic for me now, and Joni's sort of looped me in. Because there is often and almost always interaction between IP and the underlying tech in the crypto space. So that's where I'm involved, and I love being involved in this. But Joni's asked me to sort of pop in on this particular issue because of some of the material that's come out of this UK discussion paper. Now, it's quite interesting, because one of the things that they say, I mean, some very curious language in the paper I noted, talking about unsevered limbs, for example, is rather odd. But one of the issues that they seem to be saying is that if a digital asset, and I'll come back to taking Bitcoin as a starting reference, it falls within some kind of other legally recognised regime, then you're out, you're excluded. That's sort of where I can talk to these points as to, well, what exactly is, looking at Bitcoin, for example, what is it? You know, everybody has a view as to what that actually is, but we'll come back to that. But here, really what we're looking at in terms of anything that is on a blockchain is a set of data. It's information. And different countries around the world apply different rules as to whether or not mere data, mere intellectual information is personal property or not. So, for example, a patent is an invention. That's a statutory creature. It is personal property, and most major jurisdictions recognise it as such. So something that is an invention or patentable subject matter would be necessarily excluded, for example, from this potential new category that the white paper is talking about. But let's look at BTC, for example. Now, a blockchain is simply there's underlying source code that operates it and allows nodes to do their work, allows the miners to do their work. And then if I own half a Bitcoin that's currently sitting in my private wallet, what do I own? people talk about ownership of a Bitcoin, but what I actually own is a set of data, some ones and zeros, if you take it down to the machine code, that is really points to an address on the chain. And it says that that little bit is something that I control at the moment because I have the private key to control that. And then I can send that off, that piece of data to somebody else in the form of a transfer. Now that's different to me holding a $50 note, for example, for a whole bunch of reasons, but the most important of which is that every major jurisdiction has currency legislation, which says that that $50 note is, well, what it actually is a promissory note that says that if I walk into the Reserve Bank of Australia, for example, I will get a value worth of $50, if that makes sense. Now, the same logical thing applies to Bitcoin. So if I have 0.5 of a Bitcoin, I have that notional value, but Bitcoin does not have behind it legislation that says it is personal property, whereas a $50 note does, if that makes sense. So at the moment, you look, what do I actually own for the purpose of looking at the technology? Well, I own bits of information. Now, under Australian law, you cannot protect with any registered intellectual property rights mere data, save as to one thing, that is where you have a database where skill and labour has been made, injected into that to create the database. Yellow Pages is an example of that. But Yellow Pages, all of that is contains information, a name, address, and a phone number. So those bits of information in and by themselves are not protected and are not a personal asset. So information by itself is not personal property. And so therefore, tick, we're okay so far in terms of what that UK white paper is saying. The UK itself, oddly, is a little bit different to us because they do have what we call a sui generis right, or a specific statutory right to databases. There's a European database directive, which it remains part of obviously EU law, but the UK retains that post-Brexit. We do not have a database right here. So if you sort of look big picture, well, the blockchain for Bitcoin is a database. That's how I see it. No doubt a lot of you will know a lot more about the tech than I do, but that's my, I mean, I have to look at the tech and wearing my IP nerd hat from time to time, but that's how I see it. So at the moment, however oddly worded that paper is, Joni, I think my sort of initial thought is that that Bitcoin, just looking at Bitcoin only, is not something that would otherwise be protected by standalone legislative protection or otherwise as a personal asset. So, yeah.
Well, and so let's just interrogate that a little further. I've got two streams of interrogation. The first one is with the Yellow Pages example, like there is a centralized company behind that controls the production of that database, the Yellow Pages book. But in the Bitcoin case, we have many of, the 40,000 plus nodes all around the world that they are all responsible for maintaining their copy of the database and ledger. So that's where we go one step beyond sort of this realm of a centralized entity bringing into existence one database, and that's the source of truth. Whereas we get our sense of truth or our sense of integrity in the ledger because there's many databases reaching consensus, and that's the decentralization. That's the policy goal worth protecting, because it gives us the trust in the ledger. And so, Susanna, did you want to say something?
Can I just clarify, going back, James, to what you were saying before, just to make sure I'm on the same wavelength. So James, you were saying you see blockchain as a database that's not otherwise protected by legislation. So are you saying that you agree or disagree with the idea that it could be something that falls under a third category of personal property?
From what I've read in the paper, and again, I only saw it yesterday.
That's okay. No, I'm not.
Yeah,
I'm just trying to follow the line of reasoning, because
yes.
I hear you. It is a database of sorts, but it has some other features that makes the information in that database stand alone in terms of a subjective but value proposition, whereas data and information in a pure database may or may not have value in its own right. If you were to take that little bit of information out of the database, the same thing if you take the transaction record or the string off the blockchain, what is that thing that is not useful anywhere else? It's only useful by virtue of its symbiotic relationship with the
Yes.
infrastructure of the chain that Joni's talking about, with all those nodes and things. So
Yeah.
I was just interested in your initial thoughts as a building block for me following the rest of the conversation.
Absolutely. So look, my preliminary thought is that what the paper is saying is that if you can get protection elsewhere, right? So you're a database that's protected under an EU directive, for example, or you have a patent over something, then you can't, this won't work for you, this new class. So my preliminary view is that none of the existing statutory regimes that would otherwise say, tick, yes, this is personal property, apply. And therefore, I think at the moment, we're okay in terms of not being excluded.
Got it. Okay, thank you.
Data object definition,
yes.
At least the second criterion proposed.
Yes, if you apply Australian law, yes. Because all it is a chain that gets slowly bigger each time, but it's just information that's on the chain.
But actually, Susanna, you bring out an important point that maybe James you were more articulate on with the question, is the second criterion is that it needs to exist independently of the legal system. And they haven't actually defined that as the law of England and Wales, UK legal system. And so you could get into really messy territory if it actually refers to any legal system around the world. And one country does bring in law to specifically recognise your rights in relation to the Bitcoin blockchain or others.
That's a really good point, Joni. And they do use some of the examples about the EU voluntary carbon credits, which wouldn't be laws of England and Wales unless they were ratified to be relevant. And I'm not an expert on those laws, but I think they have possibly contemplated some other laws. So yeah, that's a really interesting point.
Yeah, and on that, I'm not so sure. I mean, I'm familiar with the database directive in the EU and now the laws of the United Kingdom. And I'm not so sure whether necessarily the Bitcoin blockchain would be regarded as a database under that law anyway. I don't know the answer to that. But yes, you do get to a situation where there will be disparities across jurisdictions. So if you're trying to create in effect, a global new digital asset class, you would need to tread very carefully around the language used to include or exclude certain things.
Well, or is maybe the point here that where we have other laws that give characteristics of property to something that would otherwise be pure information, what we're doing here is actually finding a bit of a fail-safe or a catch-all for things that are otherwise outside of those other regimes. So it's not so much about being a comprehensive thing, but it's saying if there is something of value that isn't otherwise recognized as property and it is in digital form and it just satisfies these things, then we're saying that is something that the law ought to recognize where previously we didn't, because there is now technology that makes that little bit of information do things differently from the way that we viewed information in the past. So I wonder whether this is more of a,
well, yes,
that fallback provision, recognizing that there will always be other legal regimes that apply, but they would serve a purpose and a very direct purpose that would mean you wouldn't need to rely on this third category for data objects.
Yes. It's curious language because if you take it to a granular level, there will always be some form of legal system that applies to anything. I mean, I have a little bit of trouble with that language.
Yeah.
Let's take NFTs. So NFTs have a problem applying this because an NFT, let's just say it's an NFT, and I think it's different whether it's an on-chain or off-chain pointer as well, by the way, but let's just say there is an NFT for an artwork, then that would not fall within, on my view, that would be excluded because copyright applies to the NFT and protect it. Yes.
Necessarily the token ID, but
Yes,
everybody in their shorthand way of understanding their interactions with the NFT is that I own
They lump
NFT,
them together.
therefore I own.
Yeah,
As
yeah.
opposed, yeah, you're absolutely right. There will always be contractual provisions, albeit the most often inadequate in terms of what's tied up with the object that the NFT is pointing to.
Yes.
But what is the token? How do we recognize the ownership or control rights or the inherent value in that little bit of information? Could be potentially quite powerful, but that there are separate legal issues that deal with the subject matter of the token.
Yes, look, it's I mean, if you're talking about an on-chain work, I'll use the term work, then I think that is arguably different, although it does sit separate to the actual data that is the token, of course. Look, I don't know. I don't profess to know the answer to that. My gut feel is, though, that if you read the words of that paper liberally, that it would be caught.
The paper says this sort of comprehensive consideration of property rights is the necessary first step before you can think about regulatory, prudential, tax, and other law reform. And Suze, your comment before that there might be other more specific legislation that does give a token the character of property in the context of tax, for example, then that's how the tax law wants to deal with your interaction with tokens. But so this is a bit chicken and egg, because Law Commission is saying, no, you've got to get the property fundamentals right first before you look at extra policy making stuff which might incentivize or disincentivize activities in your country.
Yeah, and that's true. I wonder whether, though, I mean, and you will know, Jodie, but with the tax, I had sort of understood that in the paper to be more akin to the fact that we have various legislative frameworks that treat things of value on an assumption that they are some form of property. And therefore, once you give something the designation of being property, then it makes it easier for all of those other frameworks to think about them and absorb them into the way that those frameworks operate. Now, there's no certainty that, you know, the tax law wouldn't go and make different treatments, but does giving that data object the characterization of property help then that sort of absorption of that concept into other legal frameworks?
Well, if we bring it back to its basics, it's supposed to be about certainty to contract and have bargains with other people. And if the other person doesn't fulfill the bargain or something happens, you've got rights in relation to that other person. And well, at least that's a thing in action. And so with this technology, that means we trust in it really only when you've got that sufficient global decentralization. We can't just have a cause of action and a remedy where I sue one person. It's got to be more social reconstruction where even at the tokenomics level, there's a way that somebody proves they've lost their tokens and they'll never be able to, or they've lost access to their tokens, so they'll never be able to move it again. or it's been stolen, and therefore, you know, each new block, they can be made whole from the wrong that has happened. And we haven't had to deliver a remedy that requires social consensus and delivery through the protocol before. And I think that that's the policy problem to solve, and that we're trying to solve with certainty of property rights. If you in fact have lost or have suffered the property of being stolen, which goes, and that's the foundational level before we think about whether it's a security or, you know, whether it's taxable, for example.
But Joni, at the moment, the ATO treats, if I buy and sell Bitcoin now, it treats it as a capital gain, doesn't it?
It does. And the ATO public ruling on this goes into quite some detail, and they compare all of the features and characteristics of the Bitcoin protocol and a person's holding of Bitcoin to the Ainsworth test, basically, or tests. But they essentially conclude that because of the public and private key pair relationship, which is an output of the database schema, or the source code, I suppose would be a better way of saying it, that is something that is identifiable by third parties and sort of alienable, because I, through signing with my private key, can divest myself of at least the state of the blockchain, which may have value. And I can only do that if I have the relevant private key that connects to the public key address. And therefore it met enough of those Ainsworth characteristics of identifiability, divestibility, and so forth. But I'm not sure that the right questions were asked, because there was no consideration of licensing and source code and whether a database and copyright is actually what the Bitcoin protocol, or under sort of a Creative Commons license if it wasn't specific. And so, James, this was the next level of my interrogation of you, and maybe we need to get some of those database lawyers from the EU and the UK to consider this from that perspective. Is if I was Satoshi and I have put my effort into writing that white paper, and the source code on however many forums it was that everybody copied and begun mining, if I haven't turned my mind to what licensing framework that is, whether I want to retain the commercial right, obviously I didn't, because there was a desire for it to be copied and used. So let's assume it's CCO and full commercial exploitation, because that's inherent in the tokenomics, that each miner needs to earn Bitcoin from their processing of the protocol. Isn't that a license? And therefore, if I'm holding Bitcoin, I have a license to use that network? And is the license with the miners or with the initial owner? And forgive me, that was a bad example, because I'm both Satoshi and the Bitcoin holder.
And you also hold the highest number.
Just heard it from Joni first that she's Satoshi, everybody. Just watch out. There's a confession. Yeah. She is Satoshi.
Look out.
I created this mess.
Why don't you have the answers, Joni?
I'm drip feeding them.
The issue there is that, but putting us, we'll come back to what the code is later. But having a license, if I have a license to do something, say for example, I have Microsoft Windows right now, we probably all do, and we all have a license to use it. A license depending on how you break that down, is not personal property. It is a right to use someone else's personal property for a period of time in consideration for something. Now, with the Creative Commons license, that consideration is zero ad infinitum. Now, and the reason why it's not is because the license is governed by a contract. So just the CCO contract, for example. I mean, there's a lot of talk about use of CCOs at the moment around NFTs, for example. there's a whole, we could have a whole session on that, because there's real issues around that, I've got to say, because they don't contemplate the creators of the artworks, for example. But parking that, with the blockchain that underlies Bitcoin, for example, it is all open source, as you say. But who is doing what? The person playing the role as a node is very different from me with my Electrum wallet here. And what I do with, if I decide to send a parcel of ones and zeros to Joni, to your Electrum wallet. The way in which it actually works is vastly different. Now, so going back to your question, which I think your question was, well, if I'm licensed, does that somehow potentially make us into the realm of personal property, or therefore start to trigger some of the matters that are raised in the paper? Maybe, but I don't think so. Again, I really haven't thought about it long enough. It's fascinating, and I'm going to do a lot more reading into this. But at the moment, I just don't think that it changes my view on that.
I can give a bit of context, because from a tax perspective, it matters.
Right.
And my relationship, well, my property rights vis-a-vis my relation to the person I am buying the Bitcoin from, or generating it with, it's got a different tax treatment. And so when I'm sending some Bitcoin to you, James, and so I'm a user in this example, and I've sent 1 Bitcoin, and there is 0.01, I'm not getting the maths right here, but it's just for the example, but 0.01 is the fee. And those fees, as we know, are collected, and the winning miner gets both the fees and the Bitcoin reward per block. Now, if I actually have, at that time of interacting, so what I have is a right to spend unspent transactions on the Bitcoin blockchain. When I interact with it and I spend that 1 Bitcoin, and including with a portion of fees, does that fee payment actually represent the royalty, or the payment for use of the network? So it's not a fee for use, as if I was engaging with a normal company providing me services, because I'm using the software more in the Microsoft sense of the word, I suppose, when you pay the annual fee. But in this case, it's transaction by transaction. Those are those micro, and it could be characterized as a royalty back to, but in this case, the node is, or the winning miner is not the copyright owner or the personal property owner, but it still seems like it could be in the nature of a royalty, because it's for my use of the software, or my commercial exploitation of the software, depending on what, if I'm paying you with that 1 Bitcoin, whatever that was for.
Nathan, I think, might want to say something. I'll say something in relation to that, because I'm certainly not a royalty in my view.
Okay, we'll go to Nathan and then back to you, James.
Yeah.
Sure. It's not that relevant, but something that's happening currently, and I think will continue to happen, is trying to integrate licenses into the actual blockchain itself. So rather than me needing to trust a company to uphold their end of the deal in giving me the licensing agreement, or like even with Yuga Labs, I don't actually own the license to a Bored Ape. I'm borrowing the licensing agreement to the Bored Ape, which is even further stretched away from what they promised, which is why there's heaps of controversy and problems, as you mentioned, James, around owning NFTs and what copyright you actually have and how you can use it, and what would happen to derivatives, right, of the NFT you own. Do you own it forever? What if you sell the original NFT? There's heaps of stuff going on around that, and no one knows anything. And again, we're trusting the main source to uphold their end of the bargain. But what's happening, and it's been kicked off with A16Z releasing their Can't Be Evil NFT licenses, which is epic. If anyone wants to hear about it later on, they're going to integrate through actual code into a smart contract for Ethereum originally, and now definitely expand to Flow and Solana, all the big NFT blockchains, actual licenses at the base layer, which means when I'm buying an NFT, I'm also buying the licensing agreement rather than trusting this corporation, as we discussed before. So hopefully that trend continues. Otherwise, there are just going to be serious problems in a world where we're saying we want to trust this blockchain, but we're trusting corporations that we got no idea, and they're they're worth billions, and they're pretty much driven just by money. So that's problematic. Anyway,
Nathan, I definitely want to talk to you about that.
Worthy of fleshing it out in this call too, because that's, even though you say it's at the base layer, it's still kind of application level, because you're deploying the NFT contract or the other Can't Be Evil license still at the application level or the contract level. We're still not dealing with the base level of whether it's a proof of work chain or a proof of stake chain. What are the rights that you're actually dealing with? So can we go to James and then we'll come back to that?
Yeah. I mean, Bored Ape, the license agreement was hopeless. And there was a huge debate around, nobody quite knew, well, what rights did the person get? First of all, whoever, the commissioning with copyright law 101, whoever creates a drawing, a picture, a novel, a book, or artwork owns the copyright. That's whoever creates it. Step two is usually if they're employed or they otherwise commission it for someone else, they are commissioned by someone else, that other person owns the work subject to a contract, right? Then that person can do whatever they want with it. So assume, the number one assumption is Bored Ape Yacht Club obtained the copyright at that stage under United States law to the actual apes, and then they're licensing them out to all the people who buy the NFTs. With that comes the ability to either do everything that the copyright owner has otherwise the ability to do, to reproduce, communicate to the public, to make adaptations, etc. i.e., I'm going to put my Bored Ape on my t-shirt, I'm going to go and flog it off to the world. There's a big debate about all of that. But we can talk about, I can talk about that for hours. Going back to this issue here, the Bitcoin mining fee is definitely not a royalty. It is required by the underlying code of the chain that was originally created by Satoshi. So it is a mechanical operation that rewards the expansion of the chain. It's not a royalty. It's not, it's interesting as to how the ATO would treat the little tiny bit that is the thing. I mean, Electrum splits that out. Obviously, you see if I fire you 1 Bitcoin, it'll fire 1 and then take 0.0001 or whatever off mine as well. But it's definitely not a royalty, and it's definitely not, therefore, referable to one's use of the software that underlies the chain. I can be definitive about that, unless someone wants to persuade me otherwise.
Well, no, I think that's right, but it's also confused because you're not paying the royalty to the owner, you're paying it to somebody else who is.
Yeah, you're paying it to somebody who's using electricity to run a mining machine. That's the deal. That's the deal that that Satoshi set up. That was the magic of it. In fact, what should have happened is that he should have got a patent for it, and then it would be something that was licensed to all nodes and then all users through an end user license agreement.
And an end user license agreement type arrangement is definitely not what I am if I've got some Bitcoin in my Electrum wallet. Like Electrum, software provider aside, am I just an end user again, like that I've just got this license or right to use or to spend unspent transactions, and I don't have property, I have a right to spend?
Yes. You are.
Say that again, Joni.
Well, it goes back to James talking about currency, and we only have an understanding of fiat currencies because every country has its regime of what is currency. So my right to spend is legislated. But in Bitcoin, what I actually have is a right to spend, but there's no legislative framework that tells me how to characterize that, and therefore the default is I'm shorthand calling it property, and it's not quite a license either. I'm not the end user of this software that is being licensed to me and to the world.
No, it's not Microsoft Windows analogous, but you are using the MIT notional license to be able to think of it like it's almost like, I mean, I like metaphors where you can apply them, but it's like you're buying a ticket to use on a subway, and you don't own the subway, you don't run the subway, but you've got a ticket to use it, and the ticket's your MIT license. You know, if you Electrum, you have to approve the MIT license, right? When you same with any input, and you're buying a ticket to ride the train, right? You don't own the train. You don't do anything with the train. Someone else looks after the train, makes sure it's running smoothly, running on time. Someone else pays. You know, your ticket helps pay the driver of the train and helps the people who operate the train system. That's your minor fee. But that's the best analogy I can think of to say here. But your ticket, but then that comes back, and maybe this is where the analogies, as they always tend to do, fall down at some point, is well, your ticket is a personal bit of actually, well, save as to what the ticket conditions of sale are. It's a personal bit of property that you could then hand to your friend to ride in your place. I don't know, maybe that's a bad analogy. That's how I think of them.
Well, I think what you need to add to it is, if there is a road level railway, I pay maybe $1 for my right to entry and ride on the train. But if there becomes an air, you know, this U-Butte, very fast thing that hovers in the air railway, then that's $10 for my right to use that one. And so this is where the Bitcoin blockchain, the air analogy is because it's sufficiently globally decentralized. So the ticket costs more, or the Bitcoin is worth more, even though the fees, the actual operating costs might be lower. But you don't want to transact on the road level railway lines, because I don't know, maybe it's clunky, they're not investing in the infrastructure, it's not as decentralized, it's not as safe, it's not as secure. So it's not the best analogy either, but we're dealing with multiple railways, because I can choose whether I want to interact on the Bitcoin blockchain or the Ethereum or whatever other one.
Yeah. Well, and what about though that if I don't have a private wallet and all my Bitcoins are stored on Binance's exchange, does that change the parameters here? Because I think it does.
Yeah, those are the later chapters. So we can deal with it quickly today, but we'll dive deep into custodians and centralized custodians, and their terms and conditions certainly haven't been clear or good about what your actual rights are, whether it's a bare trust relationship or you've actually disposed of your beneficial ownership, if these things are property, and what their rights, what a customer's rights are in relation to the exchange, given that there's been a number of ones that have failed. But it basically comes down to what they've written in their terms and conditions, and it's unclear. But the mass market has the expectation that it's almost like money in a bank account, where it should be segmented, it should be theirs, it shouldn't be used for other purposes. But that's not the truth. So I know this has been quite an esoteric discussion, but I can't move on from, or haven't been able to move on from it, because it's so critical to understanding whether that second criterion is actually robust enough to recognize a lot of tokens, and particularly those blockchain level native tokens, as under this third class of property. So I just welcome anybody who hasn't put their hand up or would like to speak. You know, please feel comfortable to say what's going on in your mind. I know these discussions can be a little bit intimidating sometimes. They are for me too. Don't worry. But put your hand up or put something in the chat, and we can make sure that it comes to the front. Varun, just dealing with your comment about the countries who've adopted Bitcoin as an official currency. What happens if Germany or India approve Bitcoin as their official currency? Does that throw out all of the current thought process regarding how we treat Bitcoin? Yeah, and James, perhaps, because then we do have the other legal systems recognizing it as, well, it's not independent of the legal systems anymore. So perhaps, yeah, the criterion fails already, at least with respect to Bitcoin. And maybe it's only a Bitcoin issue, because I haven't heard any other countries wanting to declare ETH as their functional currency or declared as legal tender.
But it will be interesting when countries look to seriously adopt stablecoins and CBDCs and other types of, so it's a really valid point.
Yeah, and great point, Jana. There's a skepticism as to whether Germany would adopt Bitcoin as its official currency. But it goes into this other point of I haven't seen the or entrepreneurs, at least not from an Asia or an Asia Pac perspective, gathering together to launch the DAOs that we saw launch in 2017, 2018, 19. So the likes of Compound, MakerDAO, even, you know, the Bitcoin, which I treat as an early example of a DAO, and Ethereum, we haven't had those projects with the aspiration to be truly global and the market traction. And one of my theories around this is that the regulatory uncertainty and, you know, increased resources for regulators to review these things and the fines and penalties involved, they're already stifling the innovation. So I don't know that we are having much more many more entrants to this DAO space, and it's the DAO tokens that are in the top 10 and the top 20, aside for the emergence of stablecoins. Now, the traditional finance sector, they do see the benefit of this technology. We're seeing more and more of them announce their own projects around privately issued stablecoins or input into CBDCs. But if they advance all of the, you know, natively digital payments, but we don't have the infrastructure, the DeFi infrastructure or other decentralized applications being built, we will have stable coins and we'll have the ability to have natively digital money, but we won't have had robust testing to that global level that we've had in years before, which the DeFi protocols have benefited from, because we're just not getting global launch DAOs as much anymore. And so I think perhaps a lot of attention will go to these stable coins, but what I'm interested to watch for is this mismatch between the advancement of stable coins and regulatory support or lack of support for them versus DAO tokens and testing in the truly global ecosystem that we've had in the years before. And so if that's a policy objective to continue those DAO tokens and the innovation that we've seen, I don't know that this, you know, the third class of data objects does advance it so much, because the main thing is that you're getting users to interact with your protocols, regardless of whether the token is a property right or not. It's more about, do I have to use it and hold it for a long term, or is it a short term utility? There are definitely speculators that come in and that invest and want to day trade or receive the profit, but there seems to be a lack of criteria or a lack of understanding that that's the innovation and the new thing to solve for. So I don't know if that's just me going on a tangent now, but I can move on and we can actually get into chapter 6 if everybody's ready to go through that. Okay. All right. So chapter 6 is about media files. And if you've had a chance to look through the chapter, well, digital files and digital records. And one of the first things it goes through is media files. there's two different ways of describing media files that are proposed. Basically, the shorthand version and a longhand one, where the longhand one to me felt more technically accurate, because you've got this layer, or the paper says that the graphic user interface, or the GUI or the GUI, it's simplified things, and we're used to seeing things in such a simple way that we don't understand actually how technology is working and what our rights are in relation to each layer. And so the paper concludes that no matter which way you look at the description of these media files, it still wouldn't meet each of the three criteria. Actually, I think it meets some, but it wouldn't satisfy all of the criteria to be a data object and fit within this proposed third class of property. And so this is important because they don't want a flood of things being included in this category of digital assets or data objects, and all of a sudden it enabling customers to have different property rights that go against perhaps what the terms and conditions are when you're dealing with your media files, like on your USB stick. Perhaps we might get actions against the manufacturers of that USB drive. Don't know. So I can go through each one, but at a high level, there's email accounts, domains, gaming accounts, and I think there's a couple of other categories. So if any of those categories struck you as needing to fit within this data object category, because the Law Commission concludes that none of them will, does that feel right to you? And then I'll say, does it still feel right if we can tokenize our email account, or tokenize the reputation or the metadata from our email account?
Sorry, Joni, I missed the first part of that question. Can you just repeat that again, please? Sorry.
Oh, just across chapters 6 to 11, which deal with different types of digital assets, the Law Commission concludes that none of them would meet the three proposed criteria for a data object. Therefore, we don't have to worry about the unintended consequences of all of these types of digital assets being brought into this third category. And so I just said, does that fit with you as a base case? And then if you don't have a strong feeling, what about when we start to tokenize these things or parts of these things? And the example was, I either tokenize my email account, like some people are tokenizing their Twitter profiles, or if I extract my data, which I can do with my Facebook profile and other accounts, largely because of the European laws, where there's more of a recognition of personal and private data. I should own it, not necessarily the organization. You can pull the data and you can own it and tokenize it. And I don't know that that's all adequately dealt with in the various centralized entities, terms and conditions yet to stop you from tokenizing parts of what's held in your email account or your domain, the analytics that go to your domain history, or even your gaming account. Does that make sense? Or did you have any thoughts?
No, it's a good question. I don't have many thoughts on it now. There's so many moving parts to it. But yeah, I'd leave it for anybody else to contribute to that.
Joni, it's a really interesting one about extracting your data from, say, a social media profile. Just because I take that information from the profile and tokenize it doesn't mean that the platform doesn't already have a copy. So what is the benefit of me doing that? So I think there's a big question there around, why is an information property to begin with? Because it's not exclusive and all of those criteria.
Well, it's because if enough people do it, those centralized entities won't get as much revenue from selling the data as they otherwise would. Because if there's 100 or 1,000 of us tokenizing our data, or at least extracting it into my wallet, and there are other algorithms that come in and they say, oh, Joni, you've got this data that we're interested in, we'll pay you directly $100 if you share your
if
data.
there's another marketplace or source of value for that information and it becomes usable in that context. But then again, we would get to the situation where the token might be a data object, but the information that the token relates to isn't necessarily.
Yeah, and I still don't feel like we've hit the nail on the head there with what is the right vis-a-vis the token, or what the token refers to.
Yeah, agree.
I mean, James, you touched on it. Nathan, did you want to say something?
James, were you going to go first?
I was just going to say that, yeah, the age-old issue is what right does the token holder have, and that can only be governed by one of two things: contract or operation of some statute. They're the only two things. And if the contract is hopelessly drafted, then everybody's in the dark. But even the contract can be overridden by what the general principles are under, for example, copyright law, because, you know, for example, the assumption is that Board 8 Yacht Club did get the copyright assignment in the first place, because if they didn't, then they can't license anything. They've got nothing to license.
So maybe this question only is really difficult at the blockchain level. Like, so the Bitcoin blockchain, the Ethereum code, you know, Solana, Cardano, like that level is where it's a really hard question to solve, because that's not necessarily a contract. The source code is not contract. It's not a smart legal contract. It's just an operating system that is open source. And we have no rights of recovery if it's not built into that open source software. So the software is a contract in the sense that you interact with it at your own risk. Because if you don't act safely enough, you have no cause of action and no remedy. Unless there's a hard fork. But, you know, for the individual by individual, they're not going to be enough of an inertia to cause the whole community to hard fork and rectify them. So it's just a blockchain level issue, whereas at the application level, you can get the DAO or the community to pass a vote to affect a cause of action or a remedy.
Yeah.
Or update the licensing rights, or, you know, whatever.
Yeah, exactly. The hard fork is an interesting one. I mean, I don't know how the ATO treats a hard fork and then an airdrop of equivalence in the new chain, I assume as a capital gain. But yeah.
We're in litigation at the moment to try and sort it out.
Right. We talk about that offline. But there's, on one view, if you have a community of people that live on a remote island and that they decide that a particular red colored rock possesses value and that can be exchanged, much like early bartering communities did with shells, and they set rules around how those red rocks to be transmitted. Maybe you can break them into little pieces, deal with them in a particular way. That is its own set of rules that governs the people that live on that island, right? That's Bitcoin. That's the Bitcoin system. There are a set of rules that tell everybody how you deal with these things. And it's built into the software that underlines the code in the chain.
Well, it won't be. If enough regulators around the world put pressure on the miners, or if it's a proof of stake chain, the bigger validators, they can start to introduce law to say, we will ban proof of work mining if you don't support a majority consensus upgrade to, say, restore people that can prove that they've lost their. So they could effectively censor or limit the technology by imposing still local regulations. And we saw that with the European union wanting a proof of work ban because it was not environmentally friendly enough. Or that was the assertion. So
yeah.
So it's still, it can be manipulated by the legal system or multiple, but there's a question we're not answering.
Is this being driven because people are losing their keys?
It's because of they want to drive market certainty to transact on this sort of technology. And there is, if you get commercial and significant enterprises that make a mistake, the insurance industry still hasn't stepped up to say that they would insure the hundreds of millions of dollars that have been lost and stolen. So until we solve those, I don't see the insurance industry stepping up to underwrite hundreds of millions based on human mistake. So it's got to be driven by some other way. Anyway, I won't press the point further. I think that we've really stress tested it today, and thank you for joining us, everybody. Next week, I think that we can go a little bit into chapters 6 to 11 if there's any hangover questions that we didn't get to answer today, but we'll be focusing on chapters 12 and 13 next week if you wanted to focus your pre-reading and come with any questions or things to discuss. But thanks again. See you soon.
Thanks, Jodie.
Bye.
Thanks, Jodie.
Bye.